if you were there. You start using these pronouns,
Right.
and I don't know who the hell you're talking about. Is he the judge or is he the defendant?
The defendant raises the argument that I would like to argue this is unconstitutional due to my religious beliefs. And the judge says, no, you can't raise this.
But the defendant doesn't really say that. He says, well, it's against my religion.
Mm-hmm.
And they sort of dance around this idea of a religious objection. Or does the Amish guy actually say, I object to this because of my religion?
Yes.
I think he did say that.
He did say that. Okay.
And then
I didn't know that they couldn't hire attorneys.
I didn't either.
I didn't know that either. I had no idea until I read this. That's why I really started catching my eye. I was like, there's a lot of issues with this case.
Right.
This is a great case to talk about because you're like, we've talked about arraignments. We've talked about pleas. Now we're going to talk about like the nuts and bolts, the meat and potatoes of this. Like we have an Amish dude raising a constitutional objection to Ohio traffic and criminal laws.
Mm-hmm.
And I think in another episode, a couple of weeks ago, we talked about this idea of judicial review, and you guys were learning about Marbury versus Madison. So back in, was that 1801 or something like that?
Sounds about right.
You had Jefferson and Adams. They were in this fight. It was like the Democratic Republicans versus the Federalists. And Adams lost the election. Jefferson comes in, and when Adams lost the election, he passed right before he lost something called the Midnight Judges Act, and he basically created the federal judiciary. He created the appellate courts, and among his appointments, he appointed a bunch of justices of the peace, and I think one of them was a guy named Marbury. But his Secretary of State, John Marshall, at the time, didn't have time to go serve all the appointments,
mm-hmm.
and a couple of them got left behind. Marbury was one of them that got left behind.